after 3-judge vacated conservatory orders that blocked the swearing-in of Deputy President nominee Kithure Kindiki. According to the bench, the Constitution does not envisage vacancy in the office of the Deputy President due to public interest, which paves the way for the swearing-in of Kindiki as DP, dealing a final blow to the impeached DP. As Martin Opio reports, the courts ruled that they have jurisdiction to hear the matter in question.
The string of losses followed the impeached DP when the appellate court declined to stop the 3-judge bench from making their ruling on key issues, including the request by government side, National Assembly and Senate to set aside the conservatory orders that blocked Kindiki from assuming office, following Parliament's approval.
An E522 of 2024.
And when the bench sat, blow after blow was delivered. The biggest was lifting the conservatory orders, which set the stage for the swearing-in of Kindiki as the next Deputy President.
Regarding whether the applicants will suffer any harm if the conservatory orders are not granted, we find that no individual can suffer loss or damage when the Constitution is permitted to operate as intended. Allowing the constitutional process to unfold does not in itself result in detriment, as it upholds the rule of law and respects the framework agreed upon the people. The applicants also urge the court to grant the conservatory orders, expressing concern that the respondents have a history of disobeying court orders, and that once the office of the Deputy President is filled, it will be impossible to remove the appointee, even if the petitions were successful.
The following orders are hereby issued. 1. The applications for conservatory orders are hereby disallowed. 2. The conservatory orders issued on 18th of October 2024 in Keregoya High Court E015/2024 are hereby discharged and or set aside. Costs of these applications shall be incurred. We grant leave for appeal, typed proceedings and certified copies of this ruling to be availed to parties at cost or as it may be. We will mention this matter on 7th of November 2024 at 2 p.m. in the open court.
The High Court in Kerugoya had issued orders barring Kithure Kindiki from assuming office as Deputy President, pending hearing and determination of a case filed before it. David Munyi Madhenge and Peter Gishobi Kamodho sought the orders after the National Assembly approved the nomination of Kindiki as the new Deputy President, a day after the Senate voted to impeach Rigathi Gachagua. Madhenge and Kamodho sued the Senate and the Speaker of the Senate and 2 others. In doing so, the court severes that the makers of the 2010 Constitution did not envisage at any given time that there will be vacancy in the office of the second-in-command.
As such, public interest demands that the office of the Deputy President should not remain vacant. Whether the constitutional petitions will be rendered obligatory in the absence of any orders. As we stated in ruling number 1, because the conciliated petitions challenge the entire impeachment process, the fundamental issues at stake remain live, even though the parliamentary proceedings have been completed. Furthermore, as previously noted, should any of these petitions succeed, this court will have no shortage of effective remedies to address the situation.
According to Justice Mrima, a constitutional crisis may prevail if the current crisis persists.
Suspending any provision of the Constitution, even temporarily, will undermine this principle by creating gaps in its operation and disrupting the intended balance of governance. The Constitution is structured to ensure that all its provisions are effective and operative at all times. If any provision, such as Article 147, Sub-Article 2, is rendered dormant by a judicial order, it risks setting a precedent where parts of the Constitution could be selectively switched off, effectively weakening the Constitution's authority and the protections it affords.
As pertaining to the jurisdiction, the High Court ruled it has the jurisdiction and the right to intervene in the impeachment process, which doesn't interfere with the separation of powers.
Article 165(3) of the Constitution confirms that the drafters expressly intended to exclude the High Court from hearing appeals related to tribunals established under Article 144. Given this explicit exclusion, and against the foregoing discussion, if the drafters had similarly intended to bar the High Court from determining disputes under Article 145, they would have done so with equal clarity. Nothing would have been simpler, in our view, than to expressly exclude such jurisdiction in the same manner. The absence of such an exclusion with respect to Article 145 strongly suggests to us that the drafters intended for the High Court to retain